Everybody, and I'll start again. Good morning, everybody, and thanks for joining us for what is now, I believe, an autumn breakfast. Somebody told me that the last day of summer was last Friday. I don't know if that's right. I think the clocks go, is it back or forward this weekend coming? But anyway, welcome to our first autumn breakfast briefing of 2021. And if I can start by clearing up some confusion. When the invites were sent out, you were probably led to believe that Alan Coleman will be speaking. I'm not Alan Coleman. If you don't know who I am, I'm Jason Elliott, and I head up business recovery. So if you're coming on this morning to see Alan Coleman, I'm afraid you're going to be disappointed. He was scheduled to speak today, but he's been unavoidably detained on a beach in Mallorca. So I'm sorry, guys, you're stuck with me for the next kind of 10, 15 minutes. The good news for me is that because Alan thought he was speaking, he delegated the majority of this morning to our guest speaker, Will Jones. I know that we just had a little bit of a chat before we started, but by way of introduction, Will's a partner and heads up the insolvency team at a firm of solicitors called Hill Dickinson. They're a national firm. You've probably heard of them. I've known Will for 15 plus years, and I must admit, we've worked together all that time. I'm delighted he's speaking this morning. He's going to be doing the techie stuff, the legal stuff, obviously. He's going to be talking about creditor enforcement, where we're at now, where we're going to be post the 1st of October. He's also going to update us on the landlord and tenant position, which, depending on which side of the fence you sit, will very much colour how fair or otherwise you think the current position is. The bad news is that before you get Will, you get me for 5 minutes, and I wanted to update you on recent developments regarding the bank's attitude to bounce back loans, and recent developments and arguments in terms of the pari passu rules, which you probably, if you're on LinkedIn, will have read. Don't panic. My bit's brief. I'm strictly a warm-up for the main act. Hopefully there's some points of interest in there, though, so bear with me. So bounce back loans, a 10-second going over of that. Everybody knows bounce back loan. It's an unsecured loan given to businesses that are struggling due to the pandemic. Its basis is that it's unsecured, it's up to a maximum of £50,000, and it's not supported by personal security from the directors. But provided the bank makes every effort to obtain repayment, then in the event of failure, it's 100% backed by the government. CBILS 80%, bounce back 100%. Now, if you've sat on any previous webinars that I've done over the last 15 to 18 months, you'll be expecting me to get off of my soapbox. Now, I'm not going to do that this morning. I'm not going to bang on about, being suckered in by this guarantee and thinking that it's an automatic thing, that because the bank are secured by way of this guarantee, they're not going to be interested. It's actually quite the opposite. I'm going to leave it there, but what I would say is it is obvious with what I'm going to move on to is that the bank will first of all ensure that they do whatever they can to get repaid out of the insolvency estate. It's something that there's a mandate that they have to do before they can draw down on the government's guarantee. So that brings me on to the pari passu rule. Now, if you're not familiar with that, it says that all unsecured creditors in informal insolvency must share equally the available assets. So as such, the things I've just said about the pari passu rule just says the very nature of the bounce back loan should lend itself to that. However, only a matter of 3 or 4 weeks ago, the British Business Bank, in conjunction with UK Finance and my friends at the Insolvency Service, released guidance to us insolvency practitioners, telling us how they expected us, when giving advice to directors, to advise directors to deal with the residual, if there are any residual funds that are held in a bank account, where there is going to be a subsequent insolvency. And what they said is that they believe, because they've got an automatic right of set-off, it would be unethical, I think they actually use the term not ethical, for an insolvency practitioner to give any advice to directors that included transferring money out of the bank account into, let's say, my client's account to either pay fees to cover the insolvency or to be used for the benefit of all creditors generally. And what they expected us to do was to tell the directors to leave the money in the bank account for the benefit of the bank. Now, needless to say, that was hotly disputed by myself and my peers, and probably lots and lots of Will's colleagues, and certainly our trade representative R3, who you may or may not have heard of. And what we believe is that, whilst the bank undoubtedly have a right of set-off, they don't have the right to tell us how to give proper advice beforehand. They do not have security. The basis of the bounce back loan was unsecured. They don't get to tell us how to give that kind of advice. And if they wanted security, they should have registered it. And what they're trying to do, in my opinion, and what they were trying to do through the back door, is to obviously get as much of this money back without having to therefore call on the government coffers. Now, the good news is that a form of accord has been reached, which means we can now give what we consider to be correct advice, impartial advice to directors, with the caveat that when we have our our regulatory body inspection, we have to be able to justify why we gave that advice. So needless to say, since that came out, I've done 2 or 3 file notes where I'm giving that kind of advice. I would imagine my peers are doing the same, but the reality of the situation is I can't imagine there's going to be a lot of situations where advice is given to just leave monies into bank accounts where there is an outstanding bounce back loan. Watch this space, the argument rumbles on. So why am I telling you this, I hear you ask? Well, there are 2 reasons really. One is to dispel the myth that the bank are just going to simply rely on the government guarantee and therefore they're not going to be interested. And 2 is that at this moment in time, having dealt with a number of cases that contain bounce back loans, the banks are quite aggressively making sure that the insolvency practitioner appointed, liquidator, administrator, whatever it might be, satisfies himself that the funds have been used properly. They're also putting pressure on the insolvency practitioner where he's not happy to take action himself or to report within his director's report to the Department of Business, Innovation and Skills, or whatever the heck they called this week. And I think a recent example, and again, if you follow LinkedIn, you'll see that there's a little bit of press on this one recently, is a director who has received a 6-year disqualification order whereby he took a £25,000 bounce back loan out, which he then used to fund his lifestyle. Now, when I say fund his lifestyle, he didn't buy camper vans, he didn't go to Vegas, he didn't, put it on black. He took it as wages over a period of time where the business wasn't trading, and he used it to pay his mortgage, to buy his food. But ultimately, the decision was made that that business didn't have a chance of success because he never traded it. So what he did was he just took the money, but it was £25,000. When the insolvency practitioner reported it, it resulted in a 6-year disqualification order. Now, the speed which this was concluded is unprecedented. I mean, we're talking months ago this happened. Will tell you that these things rumble on and on and on. My opinion is they're laying down a marker. Now, there's been others where they have gone out and bought camper vans, and you reap what you sow. But the one that I've just referred to, this guy spent the money on his lifestyle but to live, and they have banned him for 6 years. Now, you'll have your own opinions on that. I'm not here to say that's right or that's wrong. But the point I'm making is at this moment in time, it's not meant to be a scare tactic. Ultimately, if a business is hopelessly insolvent, it needs dealing with properly. But it's painting a picture of the current attitude when businesses are entering formal insolvency, where one of the financial reliefs has been given. CBILS will be the same. Obviously, there'll be bigger numbers probably, and the security behind that may be PGs, personal guarantees. But I'll say it one more time, if there's any expectation that the fact that it's government backed, whether it's 100% or 80%, will mean the banks aren't bothered, it absolutely isn't the case right now. It's imperative, therefore, if you've got any clients that have taken these supports out where you think the business teetering, they must be able to justify how they've spent the money. Now, the reality, guys, like everything else, is that this will settle down. We're at the outset, probably the eye of the storm. So they're very interested in making examples where they can. But if you've got any clients and you just want an opinion, don't hesitate to give me a call. On that note, guys, that's my bit done. I'm delighted now to hand you over to Will, who's going to talk to you about all the things I mentioned. So Will, over to you, mate.
Right, so hopefully I'm not on mute anymore. If I am, put your hand up. No, good. Right, I mean, thanks for that, Jason. It's quite a helpful starting point, actually, because what Jason's touched upon there is an increased willingness on the part of the government to interfere with traditionally sort of outsourced projects, especially in the context of insolvency. Now, when you look at what they're doing with the pari passu rule, what they're doing is they're changing established practices. Now, it's this willingness that's actually led to the position we're in, because effectively, what I'm going to talk about this morning is four little things. I thought I'd start with where we are now, what's next, as in how these changes that are coming in the next couple of weeks are going to impact on the regime, what the implications of those changes are for you guys, and then James has asked me just to say a couple of words about the position of landlords and tenants. So to the extent that your clients that are tenants, they can work out what they're going to do, and to the extent your clients that are landlords, what they can or can't do. But if I start with the where we are now, I think I'm not going to say unprecedented times because we're all fed up to the back teeth of it. But the reality is, what we have effectively at the moment is a nationalised economy. Now, it's not been fully nationalised, and the government hasn't taken an ownership stake, but it has heavily subsidised it. I think you'll see with the end of the furlough scheme and the slow recouping of some of the investment, you're going to see a marked difference in approach. Now, as I said a couple of moments ago, the fact that government's willing to interfere with the pari passu basis to try and improve its position, if you like, demonstrates how they're going to tinker with things over the next few months. Now, I've been asked specifically to look at enforcement actions by creditors to start with. So what we've had for the last 18 months or so is in effect a prohibition on the ability of creditors to actually bring action against debtors in the sort of traditional form of winding up petition. Now, we won't get into the whys and wherefores of that, but the reality is it was a stopgap measure to take some of the heat out of the pressure that was building as a result of the COVID crisis. So unless you've been able to demonstrate that the company whose debt you're trying to, the company you're trying to get to pay your debt hasn't been affected by the COVID crisis, then you're not able to actually present a winding up petition. Now, the changes that are coming about in the next 10 days, which are relevant to you, is that there's a change in the system. Now, it's not going back to what it was. We're going to end up with a little bit of a halfway house for significant proportions of, significant classes, of creditors. In particular, what we're going to end up with is essentially a 4-stage test for a company to go through to work out whether it can or can't present a winding up petition. Now, I know we've got a couple of lawyers on the call in theory, so they'll no doubt have read Schedule 10 of the amendment to the Corporate Insolvency and Governance Act of 2000. And to be fair, for once, I could say it's a fairly straightforward piece of drafting. They set out 4 conditions, A through D, which need to be satisfied to enable you to crack on with the petition. Now, I'll keep it light for you guys so you can understand at a high level how it works. So if your clients ring up and say, I've got this debt outstanding, I'd like to chase it, you can give them a steer. And equally, if they ring up and say, I've had this demand letter from someone, what does it mean? You're best placed to be able to give them a little bit of a clue. Now, the first condition is there has to be a liquidated debt. What does that mean? It means it's a debt that can't really be challenged. That debt has to have fallen due for payment. And thirdly, that debt is not an excluded debt. We'll come back to that in a minute. It's not quite as exciting as it sounds. Then condition B is that the creditor has delivered notice of the fact they've got a debt that satisfies condition A. That notice has to contain certain information to make sure it's compliant with condition C. Condition C is that notice is then served, and this is the important bit for you guys, and that 21 days has passed. So in theory, from the 1st of October, provided you've got a liquidated debt that's due for payment, which I'm fairly sure a significant number of businesses will have, they can serve a demand, which your clients will then have 21 days to deal with, or the targets of your clients will have 21 days to deal with. Then after the 21 days, provided they've complied with A through C, and the debt is more than £10,000, then they're in a position to present a winding up petition, which is a fairly fundamental change to what we've been experiencing over the last 18 months. Now, it's new legislation, it's technical, and therefore it's a little bit boring, so I won't take you through all of the requirements. What I would say is the beauty of new legislation is it has plenty of opportunities for people to make mistakes in it. Now, I think if your client receives a demand, the first thing I would do, if I were you, is either sit down and read the requirements of Schedule 10, or pick up the phone to someone who you're happy to read the requirements of Schedule 10 for you to make sure they've complied. Because obviously non-compliance prevents them from being in a position to present a winding up petition, which may well buy your client a little bit more time. I said at the start, I talked briefly about the implications. So the implications are essentially now, for the majority of creditors, you've got a 3-week period within which you can deal with issues if someone wants to start getting heavier with you in terms of enforcement action, and or vice versa. Now, traditionally that window was a lot smaller. You could serve demand for payment, and if the payment wasn't made, then you could present a winding up petition off the back of it. Now you have a window. Now, I think the purpose of that window is not because the government suddenly developed a heart or an economic conscience. It's to afford your clients an opportunity to try and do things to minimise the impact of an insolvency, and or to try and reach an agreement with the creditors they're dealing with. Now, I mentioned excluded debts. Now, the government so far, so I'm just going to put up the legislation so I get the wording right. Yeah, so the government so far has been fairly harsh, some would think, towards landlords in terms of their ability to get paid and their ability to take action to put pressure on their tenants to pay them. That's not changing. Initially, when I first read the legislation, I thought perhaps the government's going to allow the landlords to break the lease arrangement and then take steps to recover its arrears as a debt. But they haven't. What they've done in the definition of excluded debt, they have specifically linked it to any debt in respect of rent or any sum or other payment that the tenant is liable to pay under, in England and Wales, a relevant business tenancy. I won't bore you with the Scottish bits, I'm not qualified to talk about it. Now, a relevant business tenancy is broadly defined and would cover the vast majority of business to landlord, well, any business tenancy where you're carrying out operations in someone else's property. So where does that leave landlords? Well, it leaves them pretty much where they've been for the last 18 months. Now, that's going to be in place until March 2022. In the midst of all that, you'll have probably heard about an arbitration scheme which the government's very keen to launch. Now, the great thing about this Tory government is they've been really, really good at coming up with some nice ideas, but they've not been quite so good at giving us too much detail on it, which is, some would say, understandable, others would say reflective. I think where we're going to end up with the arbitration scheme is an encouragement to pressure landlords to accept some form of financial hit alongside their tenants to reflect the fact that the tenants have had to close for periods of time. So unfortunately, the detail on that at the moment is fairly scant. Now, it's interesting that they are effectively buying more time for the economy at the expense of the landlords by preventing the landlords from actually being able to do much. So if you've got landlord clients, I think the best advice to them at the moment is, well, I think you've just got to hang in there and see what you can agree with your tenants. And equally, if you've got tenants clients, I think I'd be saying to them, look, at the moment, you're not under direct pressure from your landlords, but unless you can readily move your business very, very quickly, they're a fundamental consideration going forward. So you need to start thinking about how you're going to deal with that debt. And it could well be that when you get to those sort of conversations, you realise that the most appropriate way to try and deal with the debt burden that's accrued is through an insolvency process, and that's where you speak to the likes of Jason and Co. I think, in summary for me, I'm not entirely sure how much of an impact the change is going to have in the short term, because, as I said, the government's shown a willingness to intervene where it's not happy with what happens. So I suspect if on the 1st of October we suddenly see thousands of demand letters flying around, the government may well, by mid-November, December, almost reintroduce restrictions or tinker with the formula they've laid down to enable winding up petitions to be presented or not presented. Because the difficulty the government's got at the moment from an economic perspective is because the entire economy has stalled and stumbled just by virtue of the fact the whole thing was closed, there is a degree of latent debt that needs to be dealt with. And if we allow those debts to be pursued too aggressively, I think we could easily take a stall and turn it into something much worse. And given the amount of money the government's now invested in the economy, it doesn't want to suddenly see all those companies it's supported necessarily going into a formal insolvency process. But that's just my view. I think what we'll probably do now is appreciate I've just smashed through that. I was told I had 7 minutes and when you charge by the hour, it's quite a difficult skill to limit what you say. It's just throw it open for 5-10 minutes to see if you actually got any questions that come out of that. I think the important takeaway points for you guys when dealing with your clients is, yes, people can petition. There are caveats, there are circumstances, but as a starting point, assume they can, unless they're a landlord. And they've got 21 days to deal with things. Now, that notice can be served either at the business premises or at the registered office. So if your client uses the registered office, you need to be aware of this change, because obviously they will have time periods which now have a genuine threat behind them, which perhaps we've not had to deal with for the last 18 months or so. So I think it's a question about just being aware and then just deciding what your clients can and can't do to try and deal with things. And one last point on the landlord prohibition. It's not an absolute prohibition. It's very similar to the position as was for winding up petitions. So if a landlord can satisfy what became known as the coronavirus test, which wasn't a lateral flow test, it was a legal principle about whether or not the business had been affected by coronavirus, then they can still petition. It's very difficult to give you any sort of steer, because the great thing about being in a common law jurisdiction is it depends on what the judge thinks. Some judges have applied quite a low threshold to whether or not a business has been affected by coronavirus. Others have applied a very high threshold. I've won and lost on the argument. The one we won we probably shouldn't have done, and the one we lost we absolutely shouldn't have lost, because it was a debt that had been outstanding for 4.5 years before. But you can't legislate for it. But I think that's probably it for me in terms of the boring technical stuff. But as I say, if you want to throw out some questions, happy to have a chat generally about things. Reassuring silence.
Well, thanks. Really, really useful. I think just in conclusion, I agree with what you've said. I think it's apparent that with the easing of the restrictions, even in its current temporary sanitised version, there will be a gradual return to normality. But I also agree that the government cannot allow this to be. In fact, I was going to finish off that I don't know if you saw the other day, but a group of MPs referred to insolvency as the Wild West. The government cannot afford to let, the Wild West, seem to happen by all these petitions smashing in. And I agree, if that happens, I think they'll have to rethink these things. But there's no doubt that there will be an inevitable knock-on effect in that insolvencies will begin to rise when these things are released in October. There won't be an immediate tsunami, that word that keeps getting used. It's a bit like the word unprecedented, Will. We're fed up of hearing the word tsunami. I use it far too often. I don't think there'll be an immediate tsunami, as we predicted. In fact, I don't think the true fallout happens for some considerable time, again, for some of the reasons you've mentioned. But there will be a need for clients to take advice where previously they might have been able to kick the can down the road. So listen, we're here if you need us. We're happy to have off the record conversations, on the record conversations, coffees, meetings, whatever you need. If you've got any clients that might just need to take any advice, then happy to do that. One final thing I would say is, other than to thank Will, and I very much appreciate it, and yes, we're happy to answer any questions, is that having touched on the Wild West of insolvency, and because I'm not doing next month's, I think in penance, I'm going to get Alan Coleman to dress up as Wild Bill Hickok when he does next month's and give you 20 minutes on the Wild West that is insolvency. In fact, we might leave that till Christmas. That'll be a nice lead into Christmas, won't it? But if you've got any questions, guys, great. If not, thank you so much for taking time out of your own diaries to join us for the last half an hour. And I look forward to seeing you all. But guys, any questions? I love it when there's no questions. It's great.
The only thing I was going to say is...
hang on, Michelle. You had your chance, mate.
It's not a question. I was just going to say, do we get any sort of information from today's meeting or webinar, like any sort of notes or... Yeah? Can you send out anything by email?
Yeah, Claire, can you and I just sort that out after this? No problem at all. Yeah,
of course, no problem.
Thank you. Cheers for that, Will.
No problems at all. I think one thing I'd say, following on from what Jason was just mentioning there, I think from your client's perspective, it's very important to make sure they understand the implications of what's actually going on in the background here. You know, the government is showing at the moment a very, very hard line. And I suspect that's to match the amount of money that's been lost, wasted, or invested badly. And as is usually the way, we're the chaps that end up carrying the can. So I suspect if you find companies now receiving notices and deciding to ignore them because, hey, nothing's going to happen, or if the landlord starts getting a bit more aggressive and there's no demonstrable sort of willingness on the part of your clients to actually try and move things forward, then they could find themselves in fairly substantial difficulties.
Agreed.
Did any of the guys from Farley's make the call? Oh, looks like they didn't. I was going to say they must have had questions, probably for the best they didn't.
I don't think so.
Guys, thank you so much for your time. If there aren't any other questions, have a great day, and look out for next month and the months after, and we'll look forward to seeing you then. Hopefully it's been some use this morning, but thanks ever so much for your time. We very much appreciate it.
Thanks for having me, Jason.
Cheers, guys.
Cheers, cheers, guys. Thank you.
See you soon. Bye.